start recording. So this is each month, myself and Michael and sometimes Tim and all the strategists get together and we have a mentoring session. So this is a session, it's a fairly open training. What I'm going to do is I'm going to go through the various aspects of the case studies. There were 3 case studies that we had on Master Strategy Day. Unfortunately, we were too busy I probably got into the weeds a little bit when I did the Moat Castle, but you'll see why it was really important. After today's session, it's a good idea to go back and look at what I did in the Moat Castle. But primarily, we're going to look and do a deep dive. And when I mean deep dive, on a scale of 1 to 10, 10 getting immersed in all the legislation, we're going to be sitting around about a 5 or a 6. So I'm going to give you my methodology of how to attack a particular client issue, what to look for, some of the strategies there. So this will definitely be worthwhile. It'll be recorded, and it's something that I would suggest. If you look at mentoring, it's not a bad idea to watch this, watch it with your staff and train them up, etc. As we go through, I'll cover a particular issue, then I'll stop and ask if there's any questions. So there's plenty of time rather than just going willy-nilly and barging through it. We've got a good hour and a half, 2 hours to go through these 2 case studies. So it's the first and the third of the line. So I'll also get the transcript for this, which we'll put up a little bit later on. And then we're going to go from there. So we're just in that process now of, I'll talk about Light Year Docs for a couple of minutes. We'll get Michael too. We're just in that process now of rolling out a few things over the next 6 months, which will be really important for all of you, particularly for strategists. I've seen the one that's sort of certainly out and about, that CPD tracker. Do you know much about that, Michael? I mean, it's only just been sprung on me by Ash, which it looks a fantastic app to manage all your CPD. And
I do, yeah. I have done a bit of work on that, and it's there's nothing out in the marketplace in relation to it, and there's a large amount of requirement around the obviously completing the CPD, but in terms of tracking it, and the legislation actually states, well, the C states definitely, and I know CA have something is that it should be managed by some sort of electronic means, whether it's Excel or anything else. And a big problem with a lot of the providers out there, such as the Institute of Chartered Accountants, is that if you do a course through them, then it automatically goes on your CPD tracker or your spreadsheet. But if it's anything outside of them, then you have to input it yourself. Whereas this is going to be a great app that will have providers having APIs into all of them. There'll be an opportunity for the providers to also provide training. As we roll it out, we'll look at areas such as if there's holes, so if it might be ethics or tax or something, as you go through towards your 12 months or 3 years. And then a provider might be I Love Accounting or I Love SMSF, or it might be Kaplan, can go in there and actually start market towards those, or you can actually search for courses, and it might be through SEPEPA related provider or anything. So yeah, it should be quite exciting, though.
Yeah, so there's a lot of stuff there. I saw my good friend Manish Sundarji is on as well, and you might have seen last Thursday we rolled out those done for you strategies, and more of those are coming out all the time. In fact, I've got about, we're going to roll one out every Tuesday and Thursday by way of social media. So watch out for that. And that will, I've got enough to go for at least 2 or 3 years, believe it or not. So, but we want to make it as methodical as possible and take all the guesswork out of building strategies and solutions for your clients. Our next one too, I know you've been working on our Light Year Docs too. What's going to be the big difference? Because I know you've been dealing with our development team over in Singapore. What's the big difference do you feel between our current platform and the new one?
Certainly, the way the documents and the interview process looks and feels will be a lot more user-friendly. The integrations that will roll out with the likes of XPM to be able to pull and drag information, do address lookups, address checks. I'm really excited about the member portal that we'll have. That will have provide strategies in there. We're going to have some strategy bots. We're going to try and we'll have maybe a grant bobblehead or something that comes up and
that'd be nice.
deliver. Yeah, and, yeah, and then we and you know, and we'll roll that through, and it'll be a bit of a community in there, and of resources and everything. So I think it's really going to grow and develop on this great. Especially this strategy center that you've developed, Grant. I know you've been quite passionate about it, and I really love it what we've got there now. I know it's in infancy, but it'll really pick that up and I think take it to the next level, which is fantastic.
Yeah, well, I think that's. I mean, for those of you here, you already probably understand that there's a lot of smart people in like your docs that we're not technologists by any stretch of the imagination. I mean, we're not coders and we don't do that, but we, get the best of the best. And then our claim to fame is getting at that pointy end of the market and looking at strategies and solutions for you guys to sell. I mean, ideally, all the strategies that either in our system or we're building are all the ones that you're looking at. I use it Abbott and Morley, and Tony does as well, and Michael does. So there's some great opportunities there for you, and I think that's instructive. Again, this is part of our 2-hour mentoring session that you get as part of the strategist subscription. Again, please just ask a lot of questions. So let's start and go through and have a look. Again, look, I don't want. I'm going to keep on. It's like a politician; they keep on, bashing you over the head with things. But I really want us to focus in here. So I was working at KPMG. Was getting pretty close. I was a manager there, getting pretty close to partnership, and really could never see myself as a partner of an accounting firm. So I left there and started work at Rothschild, where I worked there for a couple of years as the head of their superannuation, which is one of the areas that I got involved in doing a lot of strategy stuff, which I'd always done at KPMG and through my Masters of Law. And, I was probably the first one. I remember coming out of Rothschild because I wanted to set up my own business and my own advising business. And as a consequence of that, I was doing remuneration packaging, which was pretty big in those days, bit of super strategies, etc. But then really started to take off in terms of self-managed superannuation funds. In 1998, I just made a full commitment to go into SMSFs, and certainly was one of the first people in Australia to do so. And they had been around those small funds since like the 80s, the old cherry picking schemes, which are pretty famous in those days. And so I got involved there. Again, 1998, made that decision and then just went full bore from there. And look, it's been a fantastic ride. But like anything is that, and look, I'm going to continue to talk about SMSFs. So I've got, some great stuff and some great strategies we're going to be looking at today. But really, at the end of the day, it's only a small sliver when you have a look at the builders and the boomers. There's, probably around about 8 million people there. And really, I would say, and you probably deal with a lot of people as well, Mick, so you'll come up through, the hedge funds of Australia and you've been around, but I would say there's a huge consolidation of wealth in the builders and also the boomers. As opposed to the poor old X and Ys really can't. X is not too bad, but Y and Z, it's very hard for them to get ahead for a few reasons. One is obviously university fees, HECS, which is a big cost, and likewise that the boomers, because there's 5 billion of them, they've probably all got investment properties. They've got cashed up houses that bought for probably 300,000, now worth about 1.5 million. So we've now got a huge bulk of the population that really over the next 10 to 20 or 30 years are going to start to pass or be concerned about the passing of their wealth or protecting their wealth, which we'll have a look at. Obviously, one of the important things around that is if we have a look at it, if I took you back 20 years ago, the trying to get a millionaire as a client was very unlikely, particularly in superannuation. It was unheard of. You just couldn't get there because of reasonable benefit limits, so on and so forth. And even for the poor old Gen Ys and Zs, it's going to be a tough one, to build up sizable super balances now with obviously contributions caps, and the government's going to make it tougher. But what we've got now is a lot of those boomers, and certainly the builders, sitting on a lot of equity sitting in their own homes. And not that they need to go out and invest it, it's just simply that a lot of them are millionaires. So that the strategies I'm going to roll out today and show you my process, and Nick will give his tuppence worth on the way, are really built for this generation. And it doesn't mean that X and Y and Z, we don't look at those. I think it's crucial. I mean, obviously, if you're looking Generation Y and Z and X to a certain extent, if you're looking around SMSFs, it's just not really applicable to those guys. There's a lot of strategies I've shown you about using your LRBAs and 50% gearing or related party loans to at least get some access. But for all of these guys, you can't touch your super until age 60. So it's sort of a bit far out. But in terms of asset protection, in terms of succession, it's absolutely crucial. So the strategies we're doing now, and so for me, I've morphed from SMSF, so I've got that in my kit bag, and now moving into that succession, asset protection, and estate planning space, because I can see that that's where the money is. And I love developing a lot of those new strategies, and got some fantastic ones coming through.
It's quite interesting, Grant, just on that chart. There was an article last week, and this is obviously a different level of playing field, but and people should look up. But the great white shark is in the process of relocating back to Australia finally. And his article, and the article actually talked about what his next stage was, and he was talking about he will be looking after his estate planning, and for him, his intergenerational wealth. He mentioned that he'd be doing it to 5 levels, which would be great to pick up a client. I think he sold his house for 70 million, and he's divesting of half his business assets, which will bring him about 450 or 500 million. But he's talking about he's got 5 layers to go down. But perfect example of a great leading member strategy to put into place and flow it through, though. Couldn't you?
Oh, look, you'll start to see when we go through the methodology that it doesn't matter whether the client's got 1 million or they've got 100 million or 500 million. The issues we're looking at are really much the same. So the laws that apply to 1 million apply to 100 million. So that a lot of it is more at that ephemeral level where we're dealing with bloodline. As you said, he's got so much wealth, he doesn't think about, well, I'm going to give this golf course to this person or whatever. It's more about the protection of those assets, making sure they don't go outside the bloodline, because obviously he doesn't want his money's muddied up with someone else. You have a look at the classic one. I think I was talking about it the other day with, remember, you have those 3 generations. So the first one makes it, the second one builds and consolidates on it, and the third one loses it.
It's a great example.
Yeah, I mean, if you have a look at it, it just seems to be as of right. You look at guys like Frank Packer, who was a pretty hard nut, and in that space, in the newspaper space in New South Wales, Kerry Packer came along and obviously morphed into Channel 9, and did some great deals on that one. And then you got James, who came along, and although James had some great advisors, he's really sort of tanked that business, which
he's made a good effort at it, hasn't he?
I know now Crown is terrible, and one of his decisions, and this is where I'm getting to, is, obviously Greg Norman's trying to protect it the whole way down the track, because when you have someone like who's been given the keys to literally the crown jewel, so it's a bit of a pun there, James Packer, and then goes out and gets involved with Mariah Carey, and apparently the payout, he wasn't even with her that long, gave her a huge rock. But he paid out $75 million to her as a finalisation payment. Can you believe that? So, again, these are the sort of things that we're dealing with our clients, and there's plenty of stories that we know from firsthand, or just what can happen out there. So again, we want to put our little castle and get that thematic for our clients that, this is your castle, and we need to put a moat around it to protect it from the lawyers in one way, shape, or another. Australia's got more lawyers per head of population than any other country in the world. In fact, New South Wales is the worst in the whole world. And you think, well, California would be the case, but no, New South Wales is the biggest. And in terms of their business, they're obviously getting disrupted. But this litigation space and the ability to operate on a contingency fee, a no win, no fee, makes a huge bonus. You can see now the ads on TV are obviously for if you've had a work accident, get your super, get your insurances and that. So that's a good money earner. And you can also see this, have you been left out of will? Have you, not been recognised in a will? So all of these things go to effectively attacking the castle. And, on that insolvency or the trustee and bankruptcy space or all that, I mean, Mick, you're obviously pretty heavily involved there with Eventum Optimum, but, what do you see? You're saying that you're starting to see a lot of insolvencies come down the track.
Yeah, there's been a significant uplift since 31 March, which we forecast to happen, but it's definitely the tsunami is building, which is it's good for us, not bad, great for a few businesses. But everyone talked about those zombie companies that are effectively out there. But I mean, there were people were trading insolvently prior to it, and they got effectively that safe harbour to allow them to continue. And I think reality's starting to hit that after JobKeeper's gone, they actually can't. They're not really a viable business.
Yeah, look, we do quite a lot of work. Again, this is a good mentoring session, but some of you may have like some really hardcore big clients, and in that case, you just might not have the cojones to go in and really, look after them. And we've worked with a couple of accounting firms, in fact, quite a few, where we'll come in through Abbott and Morley and take the first client off your hands. And then we do a splitting of the fee where you get 25% of the fee. But essentially what we do is we go through a whole process, which I'll take you through anyway. But it is quite instructive in most of the times when we do discuss this and we go down the protector, which is super popular, that people are aware that, that the time to do it is now if you're financially stable, because then you've got that 4-year rule running. And I think that's a really important point. If we're doing that gift loan back, that gift itself is obviously no consideration. So potentially that transaction, that gift can be voided against the trustee in bankruptcy, although they tend to end up doing negotiations. But if you paid full value, and I'll talk about that a little bit later on, then it's only a 2-year rule. So again, the sooner we get in, the better it is for our clients, and the clients pick up on that pretty quickly. I won't go in. You've seen me talk about this. This is pretty famous. It's from a book called Crossing the Chasm from Geoffrey Moore, way back in the 1998. And, I still use it to this day. We've got the innovators, and, we're doing that day in, day out. You guys are helping us along the way. There's some great people who've been helping us as advisors, all of you, saying, oh, look, we've got this, can we put this in place? And then this is essentially where you guys are. You're all the early adopters, the visionaries. And of course, the spoils always go to the visionaries. And that's just the way it is. The laggards are forever chasing their tail. Many of you have, jumped onto cloud-based accounting early into the day. So you were visionaries there, early adopters. And that really came home in terms of COVID. I mean, when did you start using cloud-based accounting, Mick?
I've been using it probably for the last, let me think. I mean, if you take into BGL and CAS 360, then, probably 6, 7, 8 years. Then I wasn't an early adopter of Xero. I was, wouldn't say I was a late adopter, but I was certainly probably towards that early majority. But and I wish I started utilising Xero earlier. I was a little bit slow to the mark on that one.
I know. Some of you may not be aware. In fact, I developed, along with David Basoli many years ago when we had the Strategist Group, we developed the world's first ever SMSF cloud-based accounting platform. So this was pre-class, pre-BGL, everything. And that ended up being Total Super, which was a very interesting experience trying to get cloud-based way back in the year 2000 and 2001. I just don't think the universe was ready for it at that time. But again, the visionaries there, that's where you guys are. That's where the spoils are. That's where all the money is. And remember, $7 trillion, that's where you guys want. I'm just going to go through these, just a basic. We went through this on the Master Strategy Day, but I want to go through each one of these and just talk a little bit about it. And feel free to jump in at any point in time. So the tools that we have in our armory, and so we may use some for some clients, some for the others, but generally we're going to use a whole combination of these. So the first one is changing trusts and SMSF deeds with no resettlement. We've gone through that one before. I have seen, if you've got a really old deed, use our system to complete that upgrade to either the leading member discretionary trust or just one of our strategic discretionary trusts. But we have had a number of accountants coming through to myself with some really old deeds. And effectively we do that through Abbott and Morley, so do an upgrade there. It's going to depend on how complex it is, but we can change vesting, beneficiaries, so on and so forth. So that'll just be for a flat fee. But for some of those old ones, you'll find that if you've been through that TD 2012/21, the big issue there is to make sure it's done in accordance with the deed. I had a look at one yesterday from Liam Dunn, and I'm going to go through that and work on that today. But in order for it to be effective, can you believe once you do the variation, you have to do a memorandum that attaches the variation to the original deed for it to be effective. Now, who came up with that idea? I don't know. It was way back in 1980. Instructively, it's interesting that if you have a look at any discretionary trustee pre-2010 and 2011, generally don't have the ability to stream income, but so many accountants are still running with these old deeds, streaming income, using trust distribution minutes, which effectively are null and void because there's no ability to stream income. So you've just got to be really careful about that, because if those trust distribution minutes don't apply, potentially the trust is taxed at 45%. So I'd say, look, we're going to go through that so that there's not a big issue. So when I go through and see if a client's got a discretionary trust, the first thing I'll look at, it doesn't matter even if it's a trading trust or just a straight investment trust, I'll always change it to a leading member trust, and we'll go through the reasons for that. Modern discretionary trust, again, even just a basic one, if you haven't got your trust with 3 levels down of appointors, then there's a significant weakness there. So you can build on that. In fact, you can add appointors. We've got an addition of appointors document on Lightyear Docs. Alternatively, it's probably best just to go through and upgrade the whole process. We dealt with one. In fact, Tony it was quite interesting. Tony had done up a change of trustee, change of appointor because a client had died and had a family trust. Set it up primarily for the benefit of his spouse and also his bloodline. So everything was A-OK. Tony did up all the documentation, was fantastic. So I was just checking it off. And then I had a look at the deed. And the problem was that the gentleman in question was the sole trustee. So there was no corporate trustee, it was a sole trustee and also the sole appointor. So the first thing that I always look at is I go to, can you appoint a new appointor? And unfortunately, in this instance, if you compare it to our trustee, if there is no appointor, then the trustee can appoint someone who's been a beneficiary in the past or was able to be a beneficiary. So that helps in that regard. But here, the only person who could appoint the appointor was the current appointor who was dead. And that then led to a problem because obviously I go from there, then I have a look at the trustee clause because the trustee is dead and obviously can't fulfill those duties or responsibilities. Their executor can't come in and act as trustee because it's not allowed under the rules of the trustee. And the only person who could appoint the new trustee was the appointor. So effectively, that family trust is barren. You're going to have to go to the Supreme Court to get someone to appoint a new trustee and appointor, and then once that's done, then you can upgrade the deed, obviously, from that and put in place other appointors. So you're running by those new sets of rules. But that's a very costly exercise. It's probably going to take 6 to 9 months. And more importantly, there you can't touch any of the monies inside the family trust. So you've got the original beneficiary, which is his spouse and his children, all grieving from his death and can't touch a dollar there. So these deeds that we've got are absolute minefields. And while the Commission has given us that resettlement option, no resettlement, we fully take it, but we need to get that chain, that line of succession of appointors, which I'll look at. Leading member discretionary trust, I'm going to talk about that a little bit later on when we get into the case study, why you use that. Family protection living trust for bloodline protection, absolutely. So this is the leading member discretionary trust and the family protection living trust. They would be something, for example, if I had a look at Greg Norman's estate planning now over in the US, I guarantee you would have a living trust rather than a will. And the reason is Australia just hasn't cottoned onto it, which is very surprising because the same issues that are faced in the US and Europe and elsewhere are really the issues that we faced here. Is that, on death, we've got to get the death certificate. We've then got to take the will to the Supreme Court and prove it. In fact, there's a really interesting case in front of the Supreme Court now with lots of additions and deletions. It's a very famous barrister, quite a sizable estate. So, if the wills are challenged, you're looking at, potentially a 6 month to 2 year just to get probate, which can take a long time. And then if there's a family provisions challenge, it could take, remember the Miller and Taylor case can take up to 5 years and decimate the estate. So again, the living trust is a trust that you build and holds the wealth for the family during the life of obviously the key leading member or the family patriarch or matriarch, which then gets passed down the chain, which we'll look at a little bit later on. So that when ideally, if we've all done our work really well, there are no assets left in the estate. So a will and a will with testamentary trusts become pretty superfluous. They're still needed, but they're not really the be all and end all because we're driving everything through these living trusts, which I find exciting. And it's quite funny. I spend a lot of time watching YouTube and looking at discussions by overseas lawyers on why living trusts rather than on wills. I just shake my head and just think, well, why is Australia so far out, out of touch and out of reach in terms of these sort of things? Leading member SMSF, I'm going to talk a little bit later on around that, has the same sort of level, whoever's the first person, second leading member, third leading member. In those instances, remember, we can have a person's, if the leading member has a person's enduring power of attorney or as a parent, the children or whoever they've got, the principal, whoever they hold the enduring power of attorney for, they can act as the replacement trustee or their director inside the SMSF. So you can be a member without having to be a trusteeship, which I think is a preferable way to go for a lot of our clients. I'll talk about that a little bit later on. The protector, that's a gift loan back strategy. I'm going to go into detail before. Next week, I'll probably not next week, I'll release that with a couple of new things. In fact, we've got quite a few releases next week around the estate planning space, but I'll be talking about call options. So I'll leave that for a little second. The business protector is up and running now. So that's a transfer of property, such as IP, business processes, marketing processes, databases, moving it away from a current company or from a sole trader or from a discretionary trust into an investment trust, or what we call a leading member trust. So if you've got a family protection trust or leading member trust, you put that in because it's the crown jewels of the business. So much the same here when we have a look at it. It doesn't make sense to have your discretionary trust on the outside. You have your trading trust, absolutely, because let the litigators and all that attack that, but put all the good assets within that castle there and protect it with a moat. Most of the time, you can transfer them over anyway for full consideration, and that could be by way of a loan or a promissory note. And what happens there is that that protects it for trustees in bankruptcy, but also you can use your small business concessions as well, or restructuring, which is great. Corporate trustee, successor director solution. Most of you are probably pretty well aware of that we can, effectively, we've got a sole director companies that if something goes wrong, they're quarantined, you've got death or even divorce, it can create a problem. So we need to put in place a successor director. You'll show a little bit later on that, the leading member is a lot better version than that. SMSF testamentary trust. I'm going to show you a bit on the law around that probably about half an hour, 45 minutes. But SMSF testamentary trust is built outside the estate, so it protects us from the family provisions claim. Perhaps not so much in New South Wales, although it's yet to be tested. Kelly and DeLuca looked at accessing SMSFs via the notional estate concept under the Succession Act of Part 3A of the Succession Act in New South Wales. Insurance proceeds, probably people aren't aware of it. Again, you can build testamentary trusts outside of the estate for that. So both of those trusts, children can effectively be beneficiaries there, and they won't be taxed. So let's move on. And I want to talk about this. We had a board of directors meeting last night for SEPEPA. So we're moving along at a cracking pace. We've done the competency standards in terms of that. So for us, we're driving pretty hard, and we want to make sure that there's that ability for you guys to get accredited. And so we've built competency standards. We're having discussions at the moment with PricewaterhouseCoopers, their Skills Council, to put it on the National Register. We've had a discussion with Kaplan, Griffith, Adelaide University, Deakin as well, with the intent of getting them to draft up courses. The only problem now at that stage is in terms of membership. We're only just about to release membership packages from foundation to specialist or certified members, and then just down to ordinary members. So that'll be coming out within the next 3 to 4 weeks. So watch out for that one. Unfortunately, though, going to those larger groups, it's going to take a while, between 6 months to 18 months to develop. They're not overly keen until we hit some good membership numbers, and then the costs are going to be pretty commensurate with what Adelaide Uni charges for their SMSF specialist course. So it's anywhere between $3,000 to $10,000 per student. From my perspective, that's too much, too long, too far away, because really we want to get this association up and running and give you guys some obviously some good runway to go out and build your businesses. We've got, because we're obviously an association, we've got some really good stuff coming along. You've got a really good board there who are full of ideas, lots of value that's going to come back to you guys as well, and help you build your businesses. So the SMSF training group, which was where we've got our SMSF training group, is where we have our RG146 course for SMSFs. That effectively is up and running. So Ash from our business will be building out this course. So expected to, I think I've tailored it or set it down for the 3rd week of July to get it running. So we'll have the initial registrations up and running by next week. It certainly won't be anywhere near 3,000. It'll only be half the price of that. What will happen is you'll go through the course. On the last afternoon of the course, it's a 3-day course. There'll be a multi-choice exam that you can do, which will be an open book one. And that'll probably be 40 questions. That'll be a accreditation for SEPEPA. You'll pay $250 fee to SEPEPA for that, and then you'll get your certification. So initially, the little designation you can see on the right-hand side, you'll be a certified SEPEPA advisor. So that's coming down the track. So watch out for that one. It's best to be, again, for those of you who are visionaries, it's definitely best to make sure that you're right in the running from day one, which is really important. Okay, let's go and have a look at case study number 1. So that's a bit of a preamble there for us, and Mick's looking after all of that sort of stuff. So it's going to be pretty exciting. So let's have a look at the first one. So this is a couple with 2 children, no business or SMSF, so no business structure. So we've got Mary Smith, who's a doctor, a mum aged 43, and I have to thank Tim for these sort of ones, who's earning $250,000 per annum from the medical centre. So her contract is that each of the clients are effectively her clients, and that she then pays the medical centre a certain percentage for administration, etc. So it's not a personal services business per se. So she's not just working for the medical centre. She's actually working for each and every one of those clients. She's married to Bill, who's a year older. He's a house dad, so house husband, and earning nothing. They have 2 children, John and Lucy. A family home worth $1.2 million, owned jointly, and there's a home loan of $550 on that. Industry superannuation fund of $250 with $1 million life cover, and then Bill's got $1 million life cover and $55,000. And look, at that sort of age, when you do have a look at your super, people, we don't take into account, we just look at the straight balances. But really, that if something happens to them, for example, if something happens to Bill, there's just over $1 million which can be paid out of the industry superannuation fund, and that it's a huge benefit. Now the question is whether that goes directly to Mary or whether it goes over to the estate is an issue. In my preference, I think you're going to understand where we want to go with this one anyway. So that's our basics. So I'm going to come back to that. Again, Mary Smith earning quite a good money from her patients at the medical centre, paying a fee there. Very easy, to work. House husband, 2 kids. Got John, who's probably another couple of years at school. Lucy still a few years. Family home, 1.2 with a home loan. And, it's pretty stock standard there for that. Okay, so our thematic when we're dealing with clients like this, and when I talk with clients, I always talk about the importance of bloodline. And I can give numerous cases on dissipation of wealth from bloodline. I mean, again, you don't need much further than that James Packer and the Mariah Carey instance to show that by the 3rd generation, monies can dissipate pretty quickly. So we want to obviously protect for our bloodline. And if we have a look at the case study there, where we've got Mary and Bill, the big issue we'll talk about a little bit later on is what happens if they both die together. How are we going to protect that wealth for the bloodline of the family? And likewise, that the children are young now, but when they get to 22, 23, if they've got sizable amounts of assets, which potentially they have, are they going to be open as part of matrimonial property? And we need to work out whether it's just a financial resource or it's matrimonial property or how to protect it. So when you're dealing with clients, I always start with a theme, and the theme has to be, is bloodline protection worthwhile to you, or on a scale of 1 to 10? How do you feel about it? And generally, and I'm sure, and put your comments in the chat room if you want, that generally I find that that you might talk to clients about taxes, estate planning, etc. And there's obviously pushback on that. But as soon as you start talking about bloodline, there is no real pushback. So it's definitely the theme to go. I'm doing a bit more, obviously, going out and that bloodline of lineage. I'm doing a few podcasts on that, which will be really exciting. And I definitely know through the SAPEPRA Advisors Association, there'll be a lot of content there for you guys as well. And look, I know Tim's building a lot of stuff. So when we have a look at a client situation like this, and it's going to be any situation. So this is Grant's advice wheel, so to speak. So you're going to want to go through and deal with succession and control, and that's absolutely crucial. That's probably the most important. And there's, you can see that falling down over a number of cases. We then want to go to asset protection, superannuation, taxation, and estate planning. So they're the 5 areas that we want to work into. And it won't matter whether you're dealing with a Gen Y. Succession and control is absolutely crucial. Asset protection, they might not have many assets, but as soon as you have a family home in Australia, you need to put in place asset protection. Superannuation, they mightn't have a huge amount, but remember, we're going back to our, Gen Xers there. They might have much super, but that life cover, which is very inexpensive, suddenly takes their superannuation up to quite a sizable amount. Taxation obviously is an issue for everyone. We want to bundle all this up together, because if you can save a lot of tax, then that's even better. And then, of course, the estate planning, that bloodline family wealth protection. So if we then go down from that and start to have a look, so we're going to go down, I'm going to look at succession and control. I'm then going to look at asset protection, superannuation, taxation, and estate planning. So that's case study 1. Now, case study 3, which is going to be our next case study, we've got blended families, but I'm still going to go through exactly the 5 steps: succession and control, asset protection, superannuation, taxation, estate planning. So, and if I came and did you, I'm going to look at succession and control, asset protection, superannuation, taxation, estate planning. If I'm doing Mick, I'm going to do the same thing. So the philosophy, this slide is your money maker. Start talking about bloodline and family. Generally, if you understand about engaging clients, they might be pre-existing clients. There might be new clients, it doesn't matter. The key there is when we start talking to them, we need to build rapport. And a rapport is where you get that, you're just in vibe with the other person. So it's a subconscious or unconscious mind issue. So building rapport, there's a number of mechanisms to do it. I've got a master's in NLP, which is neuro-linguistic programming. And again, that's I find that has helped me considerably over the years. And one of the biggest skills there is being in rapport with someone, so that, once you're in that rapport, you can help them, lead them down, help them in the decision-making process, get them all vibed up, and, have a really good session, which is essentially what you want. And if you get into a good rapport, then you're very close to being a trusted advisor. And one of the first ways to get in a rapport that I find when dealing with clients, and again, even if they're pre-existing clients, it's a great way to start in, and that's to ask them about their family. How's the spouse, or if they're both there, tell me about your kids, what's happening with the kids, what's happening with the grandchildren. You want to start digging that, and these are the most important things. Don't talk over us, as we all do, but just listen as to what's happening with their family, because out of that you're going to work out, one, is the estate going to be challenged? You're going to find out how they get on with their family. Definitely, absolutely, 100% find out about, if you've got little Bobby there who's in a relationship. Thing is, who's he in a relationship with, how long they've been in the relationship, because I know that if they've been there for 2 years, now any assets of Bobby's matrimonial property under the Family Law Act. So you want to just go in and then find out, so little Sally, she's an accountant, so, she switched on money-wise, absolutely. But then you might have, Barbie, and then, Barbie is a fashion designer, but, hasn't got much of an idea when it comes around to money. So you want to find all these things out, because that's going to help you with that first one, the succession control. So, but once you start talking to clients about their family, you're starting to engage them. You're starting to get down that unconscious mind. You're finding out their deepest feelings. You're not going into deep. You're not going to go into tax sections, etc. You want to find out about their family, and that's absolutely crucial. That's why I love doing Zooms with clients. It's better to do face to face, but doing Zooms with clients is great because you can record and keep this information down the track. I know Tony uses a program. I'll have to get it to you. Some of you probably know, but you can just straight after the session, you feed the Zoom through, and then it transcribes everything. So my plan is talk to family, talk about the importance of bloodline, ask them, do they know of any horror stories from an estate planning or a divorce, where monies or wealth and bloodline are being dissipated through legal fees or challenges, etc. And then you're going to go through these 5 levels: succession, asset protection, superannuation, tax, and estate planning. So let me show you what it looks like. Okay, so the line of succession. So we've got Mary. So we're not talking about structures at this stage. What we're going to do is just talk about that line of succession. So Mary is obviously the person who's leading at the front, the main breadwinner. So for me, Mary is that leading member, the first in line of succession. So that's important. Now, I know some of you come to me and say, well, Grant, our clients really want joint. Problem is that you start to lose control. So a good response back to that with a client is, are you aware of, if you have a look at the Windsor or the English monarchy or the royal family, is there any circumstance that you're aware of in the British royal family where there's going to be a joint king or queen? And of course, everyone's going to say no. It's the same thing, because you need to have that control. You can only have one person. So with Mary, it's fine. We could use Bill, but the good thing about here is we've got Mary, and then if something happens to Mary, she's quarantined, has an accident, dies, or when she's sued, then essentially what will happen there is Mary will move out of that line of succession, appeals away, and then Bill automatically becomes the person, the go-to person in that family, if that makes sense. So with that one, it's quite interesting because you'll have Mary there, and then Bill will be the next in succession. But even when Mary's alive, Bill will obviously have Mary's enduring power of attorney and also be the executor of Mary's estate. So it just works like that. Now, with this young family, it's who's the next in line. So we can put John, who's the 16-year-old child, can be the next leading member if you want. But what I would do is I would probably, with John, and then after John, put in Lucy, but I'd probably put in place a guardianship board so that notwithstanding John is there, effectively we can be in a position that there's a couple of advisors there along with John who'll guide him until a certain age. So that's our line of succession. So Mary, Bill, John, and then Lucy. Now remember, we're building it now, and it's not as if the clients are going to die on the way home. This is going to extend out over a period of time so that, again, if we want to remove John, or if Mary and Bill look at getting separated, then what happens is Mary is the leading member. She can go and cancel Bill out of the whole equation, which is, again, another great reason to have that relaunch facility in any of our documentation. So that line of succession is set. And that to me is, once I know that, then I can start going back and building all those other structures that we've talked about in our opening to work it out. So this is the most important there for you. I have got for you, if I just bounce out of here and just take you to our strategy center while we're here, and I'll come back in. So most of you probably don't spend enough time here. I spend a lot of time in that strategy center. So as soon as you're logged in, and even if you're just a pay-as-you-go person, you can see there that we've got this strategy and support center. So the one that Michael was talking about before is a new one that we've just released. So again, we should call it the Sundarji solution. So Manish is the one who came up with this. But what we're doing is we're putting in elements there. I'd encourage you to look at this. For those who are in SMSFs, go and have a look at the pricing matrix and the strategies there, what you should be charging. Discretionary trusts with no resettlements. Again, there's a process you go through. Can a child make a deductible contribution and reduce trust income? So again, it's a good strategy. So we need to go through the 4 steps. Does the trustee allow? Does the SIS Act allow? Does the tax consequences? But anyway, I won't take you through there, but we look through the trustee, we look through the SIS regulations, the Tax Act. So if it's a child and they're employed, even if it's with McDonald's or anyone else, they can claim who can get a tax deduction, or someone can get a tax deduction for it, which would offset potentially trust distributions. And then we go through, these are the steps. So rather than having one of those strategy automations, these are just our steps, and then effectively you go through there. Good thing about this is by mapping this out at any point in time with our developers, I can just go and say, look, we want to put in place this strategy, go and build it with these 3 steps, so then it becomes automated there. So watch out for that one. We're going to build up quite a bit there. Superannuation SMSFs, why a leading member over a standard SMSF trust deed. So that's really important there. We talk about the Royal Solution, so you can copy and paste this and send it out to the clients, because some of you said, well, what do I tell my clients about leading member, why you do it? So start off with this one as probably a good resource. There's another one that I wanted to look at, and I'll probably put it in here as well. That's a good commencing an SMSF, saving tax on death benefits. If we go back here, and you'll see here in the client emails, data capture and letters of advice, there's a nice little data capture letter here for leading members. And this is a leading member data capture. It's for a self-managed superannuation fund. So again, it talks about that chain of succession. So again, have a really good look at that. If you're looking for a tool to find out where things are with the documents, I always go and do a document search. If I'm here, I'll just go in, and because it's so many places, I might go like business protector. So you'll see there. So we've got the business, personal guarantees, and you can see there we've got the business protector. Just a lot easier than mucking and rooting around all of these areas there. And if you don't, if you want to find out whether we got something, just again, go here, and one of our team will help you along that one. So we've gone through that process there. That line of succession is absolutely crucial and very important for that one. And each one's going to be interesting. We'll see when we get round to dealing with the blended families, how that may change. Now, John's come through. He's got, John said, a client wanted information about trusts. I looked on your website strategies yesterday. I could not find any general information about trusts. Can you add this? So, John, that exactly, I'm not sure if I took you, but I'll just go again. So what you want to do is, I'll go out of there and I'll show you what to do, which is the way I do it. So I'm going to go in the strategy center. Remember how we got to that strategy and support center? I just clicked on that. And then if you just have a look at leading member trust. So if you have a look at that, so if we have a look at that, there's a good technical question on that one as well. And then there is obviously automations around that and technical queries around that. We've also got, what it will do, I'll see if it's got here, trust. Okay, so change of trustee, unit trust vesting. Okay, so it's probably not there. Remember I went in here, advisor client, strategy and solutions, why a leading member SMSF over standard strategic deed. So that's, you can just email this. So this talks about what is a discretionary trust. There's another one there. Sorry, that's a leading member SMSF. Sorry about that. So that's the wrong one. That was my fault. If you go back to here, the client data capture and letters of advice, John. If we go down here, leading member discretionary trust, all you need to know, download this, and then effectively you can send it over to your client. So there's a discretionary trust summary you'll see here, and pops up in Word. Put your logo up here, or Abbott Morley logo if you want to do that. And you can see there, it talks about what is a discretionary trust, and talks about the power of the trustee, looks at the appointors, and then why a leading member family trust is a better way, and potentially also how it links to a leading member SMSF. So we've got specific resources there for both the leading member trust and also the leading member SMSF. So utilise those. Let's go back and have a look at the case study. So the line of succession is important. So now we want to go down that asset protection equation and building a leading member living trust. Now, one of the areas there is that obviously she's getting paid by the medical centre. Because it's not personal service income, I would have had that shifted to a leading member discretionary trust. The issue we might face here, and it's a bit of a painful one, we'll talk about it, is potentially if she invoices through that leading member trust, potentially there's litigation against her. Ideally, you'd have a discretionary trust or company, and then which is your trading one, or in this one, your consulting one. You'd have a separate family protection one, which is where which is basically risk-free. Now, in this instance, obviously, we don't at their age and cost, because the work we're going to do here is going to be between $12,000 to $20,000 worth. You'll see, and I'll talk about that a little bit later on. But what we want to do is to have two different trusts, because we're going to build, obviously, the protector. Might just be a bit of an overreach. What we can do is, of course, we can use the one living trust. So I do a leading member trust. Remember, who's going to be the leading member appointer? It's going to be, obviously, Mary. Who's the next one? Bill. Then it's going to be John and Lucy. But remember, there's going to be guardianships there for them. So again, have that. It's not ideal, but the good thing about it is if Mary gets sued, then essentially Mary will resign as the leading member appointer, and automatically it goes down to Bill. So it's like having traditionally as accountants, there's been a tendency to put all the assets in the wife's name. The problem about that is that there's obviously divorce issues. I won't go into that to any great extent, but it can be very costly. Here, we can put in Bill, who's the house husband, at the drop of a hat. So that's the great thing about having these leading member and trusted changes. But again, it's easy for me to build it now because I know my line of succession. So I know exactly how it's going to go, and I can build that through the Lightyear Docs site. Now, with a corporate trustee, definitely. So she doesn't have to, because it happens exactly the same thing. So if Mary's the sole trustee, then likewise, or Mary and Bill, the same sort of thing as the leading member appointer. She peels out as a trustee, and you leave Bill if you wanted to do that. So if you're going to do joint, it's not a bad idea to have joint directors or joint trustees, but remember the appointership, which is where the real control and line of succession is then you'll have still Mary, Bill, John, and then Lucy. But if you want, you can put them all in as directors or just individual trustees if you want. My preference, of course, is to have a corporate trustee. And you'll see on our site, you'll be looking at the leading member discretionary trust corporate trustee. So that's quite a specific one. It's non-dividend paying, so it's not built for businesses. It's just built to act as a trustee of a leading member trust. So in that instance, what happens is all the shares are issued to Mary. So I'll have a look, actually, I'll come back to that. So all the shares are issued to Mary. And what happens then if Mary resigns, gets dementia, divorced, is sued, or dies, then her shares are cancelled. And we do that because we don't want those shares which really control, because whoever's a shareholder can appoint the directors of the corporate trustee. So you don't want the corporate trustee and ultimately the family trust or discretionary trust to be tarnished. So what we're going to do is if those shares were sitting over in the matrimonial property, or the trustee in bankruptcy held them up, or the executor or someone making a claim against the estate, that really ties up that entity, which we don't want. So we just cancel the shares, Mary's out of it, and then new shares are issued to the next in line of succession, which is obviously Bill. But if Bill's not around, who's going to be the next in line to get the shares? That's right, it's going to be John. John's not around, it's going to be Lucy. Again, when we go through that process, they'll end up getting those shares. The Guardian board aren't directors or appointers, but they have that guardianship process there. So if we go through, that's again, that line of succession helps. Now, what we would do and what we're building, and again, this is part of our innovation space. So we've got this living trust now, which is A-OK. So if something happens to Mary, then Bill comes in and controls it. the big question you need to look at, and so once we go through that family, we go through the bloodline process, all of this, we get our succession control. One of the ones the big question you have to drop with a client at some point in time, and this is something for you to think about personally, and I'd encourage all of you to go through exactly the same process that I'm going through with the clients, to do it for yourself. And I think that that's absolutely crucial. What is your line of succession? What's your asset protection? Absolutely crucial. Superannuation, taxation, and estate planning. So what we want to do is work out that bloodline, but at some point in time, the best question you're going to have to ask the client, which will really shape them to the foundations, throws out their old wills and all that, is, what happens if both of you died yesterday? So if you both died yesterday, well, it's great, because we know in succession control that the next in line is going to be John with the guardianship board, but if John dies as well, then it's going to be Lucy. So we've got that 4 levels of succession. So again, it's I know what the answers are. Now, when it comes down here, so it's very easy. We've got Mary controlling the trust, but if something happens to Mary, who takes the next control? That's obviously Bill. And then Bill will be the primary beneficiary under that leading member trust. And then obviously his bloodline, which are going to be Lucy and John, will be included as beneficiaries, plus any entities that they're members or beneficiaries of. So they can be other trusts, etc. So if we have a look at that, the assets are going to be primarily in that leading member trust, which is a living trust. So that in the event that both died yesterday, we now need to build sub-trusts within there. And by sub-trusts, what I mean by that is that we might have a pool of assets that are sitting in the trust. John's coming in and is running that particular one, because remember, Bill and Mary are gone, under advisement with the guardian board. Then we can do an asset split, and then there can be an equal payment of benefits down to both John and also Lucy, or assets can be separately set up for each of those in terms of sub-trusts. We just have to watch out. Remember TD 2012/21, whether there be a capital gains tax issue there. Certainly won't be a stamp duty. My feeling is it's not a new trust. So we'd be okay, we'd set it up. And so what we're building now through our leading member trusts is an ability there to put in much the same way with those of you who've gone through our testamentary trusts, where you've got a line of question: who's the appointor of the trust, who's the trustee? So it's going to be both cases, but what income can they get? When can they get corpus, which is a capital distribution? Is it age 20, 25, 30? Can it be earlier if they're going to be educational? You can even go down to the level of saying requiring before any income comes out to John or Lucy, do they have to go through a financial awareness course? We can even put in there that the trustee or the guardians must ensure, for example, that if either Lucy or John are addicts, that the monies they receive must go to rehab first. So you're forcing them into rehab. So you can start to get into a lot of those issues, which you guys will actually be able to build, and you're building it through a living trust as opposed through a testamentary trust. So these are a couple of exciting new developments, which will be coming out with probably definitely by definitely before the course in July. But I would be looking at launching them around about June, which isn't that far away. Leading member versus the successor director solution. Some of you have been doing that successor director solution, which is great. So that, as I said before, in the event that if we had the successor director, Mary passes away, dies, gets litigated, etc., she peels away, then she might have put in place a successor director. Let's say it's not Bill, but it's her best mate, Julie, and then Judy comes in and takes control. The problem about that, that's still okay, and it's better than nothing, certainly, because otherwise there's no continuity of business. But we want, really, at the end of the day, we want continuity and control. So it doesn't help to have a successor director solution when we find that the party litigating us or whatever has the ability to control the shareholding, and through the control of the shareholding, just boot the successor director off anyway. So my preference is, again, using that leading member. So in terms of continuity and also strength, there's that line of succession. We build the leading member. Then if we don't have the leading member, we then go to the successor director. So it's better than any. Successor director is fantastic, but there is a better way down the track. So we'll look at that. So that's the thing. So I've got a couple of questions. Info about a testamentary trust, John. Yeah, I will get around to that. Put something on there as well. And just to clarify, is the leading member discretionary trust different to the leading member LT, which is, I'm just assuming, the family trust. So they're both exactly the same thing. So a living trust is a leading trust. What I would do, so that's a really good question. What is not a bad one to do is, through the leading member, is to use it as call it a legacy trust or a living trust. So the nomenclature around its purpose should come in the name. So it might be the Smith Living Trust, or the Mary and Bill Smith Living Trust, or the Mary and Bill Smith Legacy Trust. But at its core component, even with our Family Protection Trust, it's still using the same technology, which is that line of succession with that leading member that goes down there. Okay, so we've gone through succession, we've gone on asset protection. So the first thing we're going to do is that protector. So we've set up our leading member trust, and remember, Mary is going to transfer her fees into that trust. So instead of her just operating and doing invoicing in her own name, she's now going to move that into that leading member trust. You can do that through obviously a restructure, and that will protect you from capital gains tax. So here I've worked out they've got a home of 1.2 million with a liability of 550 on it. We've got cars worth 75 and shares worth another 75. So the net equity they've got is 800. So the process we go through is we look at that 800. That's all I care about. I don't care about the other stuff. Of course, you can transfer the cars into that leading member trust, and also the shares. If there's no capital gains tax or stamp duty, we can transfer those over. But if there's capital gains or stamp duty, we may not want that. Cars, just watch out. Obviously, you have to transfer to market value. Just watch out for any depreciation clawback. But with a net equity, if we're just transferring that over and everything else stays in the name of Mary and potentially Mary and Bill, because they own it jointly, then that equity gets transferred over. It's gifted over to that leading member trust. So you've then got to remember that 4-year window for that one. So we don't have the cash. So what we do is an on-demand promissory note. So that's part of that leading member, or that's part of the protector kit. And in that protector kit, you can actually set up a leading member trust as well. So that's important. The only thing you have to set up outside is that company. Ultimately, we'll get there with our Lightyear docs too. So now we've got on our balance sheet effectively cash, which is represented as a current asset, being the $800,000. Now, what's happening is we're going to lend that back to both Bill and Mary, or maybe just Mary. It doesn't really make any difference. So when we lend it back, what we're going to do is endorse. So what we have is the trustee of the leading member trust, or the family protection trust that we've got there, now holds that promissory note. Promissory note is a promise to pay on demand. So I could, for example, as a trustee, I could go to Mary and I could go to effectively Bill and say, look, you owe me $800,000, please pay up. Alternatively, we want to lend it back. So what we're doing now is we're endorsing that back, and that'll be released next week. So that was the one that I was always, conscious of, is that we now endorse that back so that the trustee of the Family Protection Trust sends it back to Bill and also Mary. They now own that note, promissory note, but it's from them, so it's extinguished. And you'll see in our new documentation, our endorsement documentation is extinguished, but it's replaced with a loan. So they've got the cash back. So now what we've got is an asset, which is going to be a loan to Bill and obviously Mary, and that'll be secured over the home there. And you'll see that Michael at Venom Optimum will be able to do that for that. Are you there, Mike? Or
I am, sorry.
Yeah. So do you just want to go through, because obviously if we leave it as is, there'll be the home, which will do a registered mortgage over, PPSR over the cars, and PPSR over the shares. Do you want to, just so that everyone's aware that Eventum Optimum now do that, and there's a disbursement there. So again, they should be telling their clients there's a disbursement. What's the costing for PPSR registration? For example, we've got a couple of cars or shares, and obviously registration of the mortgage.
Yeah, if it's not if it's not a director's loan or a UPE, then we shouldn't need a loan and security deed. If we need a loan and security deed, then it's $275, including 7-year registration. Otherwise, it's $110 per registration. And
that's fantastic. So it's only, so if I've got a couple of cars like a Beamer and a Mercedes, then if I put it on the PPSR, it's just going to be $110. Is that correct?
Correct. Yep.
Okay. And
that's our process costs and the disbursement in relation to that. And then to do a mortgage, whether it's first or second, it's $440 plus disbursement, which sort of sit around that $350 mark.
Okay, fantastic. So what's the process? So if I was doing this now for Mary and Bill, I've done all my documents through Lightyear Docs. How do I then, what's the process from your end, just so that people are aware of it?
Yeah, the best way is to contact us at registrations@eventumoptimum.com.au, which is EV. I'll put it up in the chat in a sec. And then we'll shoot back an email of what documents are required in the process. And we'll have to go, some of the things that we have to do are a VOI, which is a verification of ID on the clients, which is all done electronically. So it's sent out from effectively the PEX workspace, and it goes out, and the clients upload, it goes to their email, they upload things such as driver's license or passport, etc. And then a SMS text verification happens to check their ID, and scanned photo of themselves, and when they do it at the time of verifying. And then we also get a client authority form and the national mortgage form, which has to have the terms and conditions of the mortgage attached, which is effectively our protector document that provides those terms and conditions, but it has to be attached as an annexure, and we have to label such, and it has to be signed on every page. There's a few steps, but we'll just provide all that information.
It's good. While you're there, also just let people know that. So, what's the process for? Do you want to just give a note on what you do in terms of a stamping of deeds? What sort of deeds? And this is all across Australia, and also the process there, because we are getting a few questions. It's good to have a central repository.
Yeah, definitely. I mean, I spoke to a member last week and sent an email out. We've got a table in relation to that, but there's also details in our support centre in relation to which states require deeds to be stamped, and costs in relation to that. But we can stamp deeds in every state. You don't have to have them stamped in all states. It does provide that additional layer in terms of that it's been registered, but the process is effectively using that same email again, and then we will get a copy of the signed deed, and we'll lodge it through the stamping section.
Fantastic. So is it possible to get the mortgage and PPSR set out in a document so we can discuss with the client and the approximate costs?
100%. There
Okay.
is. Yep.
So that's something for Michael to do. So
We're just finalising. I expected to be last week, but we're finalising a flow chart in relation to that process and the documentation and stuff. But we'll get that out.
Fantastic. So as I said, promissory note over, promissory note back. It's replaced with a loan. Get it secured. Now the exciting thing, which is coming out next week. So make sure you log in for next week's Thursday launch webinar. In fact, you've got one there tomorrow, haven't you, Mike? What do you got on tomorrow?
No, my next one is next Thursday.
Oh, is it? Oh, okay. Well,
Yeah,
maybe.
I thought it was, but at our Monday meeting, we said it was next Thursday. So.
Okay. Oh, maybe I need to. Well, watch out. I might pop some.
Yeah.
Yeah, I'll pop in a couple of new releases tomorrow. So yeah, so I'll see. Actually, we won't have this up. We've got member exits and we've got a few new things coming up anyway. So with this one, one of the big ones that was always, it takes a while for me to get my head around things, but one of the big ones that was a concern is that if that home, particularly in a rapidly rising market that we're in, goes up to 1.5 million, the last thing we want to do is do a protection for that and then find out that we've got some equity which is left outside, particularly because once the mortgage is registered, it's registered, so you've got security over it. So the traditional way of doing it, and the protector has been around a while, but generally you get it through legal firms, and it's a fantastic strategy. But now using our system, you get to access all of that. That increase in that equity, you'd have to go through the same gift loan back process. And I was thinking about doing umbrella loans so you can just, keep on writing it out. However, what we're doing and putting in place is an option agreement so that you'll be able to flick a box. And so then the trustee of the trust, in this instance, will be the Smith Leading Member Living Trust, or whatever we like, the Smith Living Trust, effectively would then have an option to acquire the cars at 75, the shares at 75, and the home at 1.2. So that would mean then they'd pay full market value for that. So if it's at the market value, current market value, the option price is just $1 because that's what the market value is. So the good thing about that is twofold. First off is, let's say the home goes up to 1.5 million, then it now means that option, which I had to acquire the home at 1.2, that option is now worth $300,000, if that makes sense. So I'm picking up all that upside because I can go and tell at any point in time, I can get Mary and Bill to obviously sell me that home for 300,000. For 1.2 million. So the value actually goes into the capital gain, into the option, which is held by the trustee, which is also a good thing because they've paid full consideration for it. There's not a full 4-year clawback for voiding that transaction. It's only 2 years. So that helps us as well. So we'll go through that option agreement. Again, I'll probably go through that tomorrow if it's up and running by tomorrow. So I'll see if I can get my developers working. Otherwise, we'll look for a couple other things. So now let's go to the leading member SMSF. So we've gone through succession and control. Remember, it's we've gone through all of the various ones there. So we've gone through. Remember, it's Mary, then Bill, then John, and then Lucy. We've done our asset protection. We're now looking at superannuation. Now, they're in an industry fund, which is, it's okay, but really, I wouldn't I just don't. There's just not enough flexibility. The problem about industry funds, even if you put in a BDBN, I had one the other day that there was a BDBN and the trustee of the fund wasn't going to recognise it, and we're just going to let all the other dependents come in and start to attack it. A couple of things. I haven't got time today, but I definitely will have it tomorrow's session, again at 12:30. So I'll be looking at members exiting an SMSF, but we've got a new option in establishing SMSFs, and that is the accountant's letter. So I'll go through the regulation tomorrow, but under ASIC guidelines and also the corporation's regulations, then an accountant, if a client comes to you and asks you to set up a self-managed super fund, you're able to do so, provide them you give an accountant's letter that says that they should go and get financial advice, so on and so forth. So we'll cover that, but I've drafted a letter up there for you. So that'll enable you, for those of you who aren't limited licensees, to go out and at least promote self-managed super funds. And if a client comes and asks you, then that will be part of the establishment pack. So that's a fairly exciting new tool. So again, same line of succession. So what we do is in this one, we'd set up a leading member SMSF. And of course, the first leading member is going to be Mary, then Bill, then John, and also then, of course, Lucy. Now, Lucy and John obviously can't be trustees. I'll be going down exactly the same structure, doing a leading member SMSF special purpose corporate trustee. Same thing, shares. So if something happens to Mary, guess what happens to the shares? They're cancelled and they're passed on to Bill. Same with Bill, then it goes through to John and then Lucy. So you can start to see that succession is exactly the same. Now, in an SMSF, it's a little bit different. So there's three types of SMSFs. First off is the traditional SMSF. So we've got a corporate trustee. Each member must be remember the EPOA changes we made, but each director has a vote with the chairman having a casting vote. Then the next one is obviously that would create a problem, and you can probably see already all the naysayers are out there saying 6-member funds are too difficult because everyone, will fight and all that, which is a lot of rubbish. I mean, it's like saying in an industry fund, you shouldn't have an industry fund with more than 2 members because everyone will fight. It just doesn't work that way, because particularly if you do separate investment strategies. So in this instance, the other one is you do proportional voting, which is based on your member balances. So if you're having a directors meeting and you've got $1 million, or like, for example, in this instance, Mary's got 250,000, she'd have 250,000 votes. Bill's only got 55,000, so he's got virtually 55,000 votes. And if you can bring in both John and Lucy, and you can have members who have no balances if you want. So they go in there, and effectively what will happen from that is they can be members, but it's proportional. So really Mary's the controller. The alternative is we have a leading member, and the leading member can hire and fire the trustee, can appoint and remove members, which is really important, particularly in instances of divorces or family breakdowns, plus can veto any trustee decisions. Their primary focus is obviously to ensure retirement income and assets are being protected for the bloodline. So even with death benefits, the trustee can refuse, or the leading member can refuse to release death benefits unless they're absolutely going to the bloodline. So that to me is the better style. So I came up with that proportional voting back in the mid-2000s, but this is now even a stronger. It's like the same thing, the successor director, and then we have the leading member. Same here is we have the proportional voting approach, but then we've got the leading member. So it's just that next level over. We'd probably keep, again, you need to do an assessment here. The industry funds have got group insurance. So you want to keep that group insurance, but remember, you have to keep on opting into that. We have to opt into that insurance. There are companies that will roll over insurance into your new self-managed super fund, and so you'll still keep the same terms and conditions in there. So there's a couple around that will do that. So then we don't have to worry about keeping the industry fund, because it's a bit painful having your SMSF and industry fund quite separate. As I said, Mary's a leading member. Having John and Lucy as members, they can have their own separate account balances, but they're very young. It's not a bad idea. Remember, I showed you a little while before. I'll go on and have a look if you haven't had a look at it in our strategy centre. The ability to make tax deductible contributions on behalf of children. So even for Lucy, you can make a tax deductible contribution. You just need to show that she's employed somewhere. So she's employed by the family trust, absolutely. And likewise, if she wants to make a personal deductible contribution to offset against the trust distribution, then effectively in that instance, what we can do is, even if she's employed by McDonald's and she's getting employment income, then she can claim a personal tax deductible contribution. So again, go and have a look at that strategy, and it'll steps you through on what documents to do. So that's a really important strategy. Now, I found on the internet that some insurance policies actually come with children's cover. So it's a bit like, for example, healthcare benefits, that you wrap your children in. Now, that's not a bad idea, because you can see here between 2 and 17, and it lasts until age 21. So this is great for TPD, so total permanent disability, and obviously death. So I'd be bringing John and Lucy in anyway, and then just getting their insurances. So for that, use the earnings of the fund to provide insurance for both of them. You just got to check, because the only thing is, I haven't gone through myself. It talks about the insured person must be your own child. I'm presuming there that obviously with an SMSF you can go through that process as well. So I think that that's absolutely crucial. So that's our leading member SMSF. So it follows much the same as the leading member trust. Now we're going to move to taxes, and again, Mary is not in the personal services business. Actually, it's funny, isn't it? So this comes from ATO TD 2005/29, which was released obviously in 2005. Great ruling. But we've got Mary's a computer consultant who provides her professional services through her private company to a number of clients, all of whom refuse to contract with her personally, but insist on obtaining her services through a contract with her company. So that's much the same as we've got Mary, the doctor here, and her new discretionary trust. The company employs Mary to provide programming services to her clients, and employs her husband, Derek. This one, obviously it's going to be Bill, to provide administrative support. Derek obtains a market value salary for his administrative work for the company, but the company provides superannuation contribution on his behalf to a compliant fund up to his age-based limit of 95,980. So again, there is no age-based limit anymore. So effectively, it means, Bill, you could basically do whatever you want. The company provides the remainder of its fee income, net of expenses, to Mary as remuneration for her services. Mary's remuneration consists of salary, super contribution of 4.5%, which is just 9% of her salary, the minimum level of super support required under the SGC. Mary's salary is lower than it would have been if the company had not made such a high super contribution on behalf of Derek. However, Derek provides valuable service to the company for which he is fairly remunerated. The company makes genuine superannuation contributions on his behalf. There are no unusual features to the arrangement. In the circumstances, Part 4A does not apply. So that's a pretty gutsy one there. So again, looking from a tax perspective, by the first start of the equation, so the sizzle, so we're starting bloodline, but we're going to give them some other benefits. So we're going to set up their own SMSF. They'll have over $300,000 in there. If they want to invest in property, they'll be able to go and get a 70% loan. They'll be able to buy $1 million of property, a couple of apartments somewhere, put them inside the fund at that age and hold it for retirement purposes. We can then obviously stream the different income down to Bill and also Mary, but Bill can be employed by the trust in administrative area. Obviously, the money he gets has to be commensurate with his work. There probably is not a huge amount of administration in terms of, obviously, he needs to do his receipting, etc., through Xero, chasing up accounts, etc. But then from that perspective is we can make a tax deductible contribution on his behalf, which is not tied into the amount of work that he's actually done. So again, have a look at TD 2005/29. The commissioner comes out, looks at a whole lot of examples, looks at all the law around it, and essentially basically says that Part 4A does not apply. So I think that that's a really good one here. I've got a couple of questions before I go on. Does a gift have to be in the form of cash from Eddie? No, you'll see when you do the protector, it's actually by way of a promissory note. So the client doesn't need cash to go ahead and do the protector. John, for a standard trust, is the rule against perpetuity extended another 80 years when you amend the trust deed? No. So what happens there, John, is you look at, we're doing a couple at the moment, quite some of the older deeds only ever had vesting, or the duration of the deed would only go for maybe 40 or 50 years. So you can extend the vesting date if you want, but you're still stuck by the rule against perpetuities, unless you're in South Australia where there is no rule against perpetuities. So we've got a few tax strategies there. The estate planning, now bearing in mind, I've actually shifted everything out of really their estate and put it all into this living trust. We've gone through the process there. So when we come down here, if I had a look, let's focus in on that Smith SMSF itself. In terms of estate planning, in the event, I'll just have a look at Mary. It's going to be much the same as Bill. Mary, if Mary dies, she's in accumulation phase, a pension can go to Bill. First 12 months is not tested against his pension balance cap, but it is after 12 months. Or alternatively, it can go to the children, or it can be shared. So let's say you've got, she's got 1.2 million there, which includes insurance proceeds. You could give, for example, Bill $800,000 and then a couple $100,000 each to each of the children. And so they'll then get a pension up to age 25 where they can commute. Importantly from that one, so the pension stage is available there. Alternatively, you could do an SMSF will with all the money's going to Bill. Obviously, it will be tax-free because he's her spouse. So he'll receive the 1.2 million, which is quite beneficial. He can then set up that SMSF testamentary trust, which can be for himself and also his children. So again, it's protective. Alternatively, he can transfer it back into the original leading member trust. So that would also work there. And so that then both Lucy and John, even though they're minors, they'll be taxed as if they were adults. For lump sums of dependents, as I said, it's all tax-free, which is pretty beneficial because remember, we have got some insurances there because if it comes out as an income and we've got that amount that's coming from insurance proceeds, it's fully assessable. So we're better off taking lump sums rather than income streams to the extent that they can be directed back. Remember that $1 million of insurance proceeds. If it goes down to Bill, it's tax-free. But if we pay a pension to Bill or the children, then essentially, because she wasn't over age 60, when he receives it, it'll be assessable income in his name, and same with the children as well. But it's not taxed at the highest marginal rates. So again, we can sop up some of that income by way of the kids through obviously the tax-free threshold and low income tax offsets. So just watch out the difference between there. But a lot of this stuff, as you can see, we're looking at a thematic level and going in, and I'm just saying, well, this is what we're looking at. When we go into our 3-day course, we'll actually be going into legislation here and pulling apart the actual sections. So you have that ultimate confidence there for you. Again, watch out for that in the next week or so when that's released. Lump sums, though, to non-dependents are taxed at 30% for insurances and not income streams. So with the Smith Leading Trust, then just continuity just carries on. Distributions are taxable and sub-trusts, as we talked about before. This is the SMSF Death Benefits Trust. You'll see when you build this, and look, I've got all the money going to Sally Smith. This is just an example. So this was, for example, if it's Bill, it's going to go to Sally. So we've got all my superannuation interest. This is paid directly. So it says this benefit may be paid as an income stream as allowed under the super laws or transferred directly to the designated beneficiary, which is Sally in this instance, or any trust company, person, or any other entity the beneficiary directs, including a transfer to the deceased member's estate. It has to be held specifically for the beneficiary or in a trust for that purpose, which you can put into a super proceeds trust, but then it's open to family provisions claims, which you don't want. So the direction of the beneficiary or any leading member, the trustee may create an SMSF Death Benefits Trust to hold the designated bequest. The SMSF Death Benefits Trust is a discretionary trust whereby the beneficiary or their assigners will be the trustee and appointor. Further, the beneficiary would be the designated primary beneficiary of the trust, along with any lineage or such other beneficiaries, as the beneficiary includes the constituent SMSF Benefits Trustee. So again, if you could just go down, that's that testamentary trust where both John and Lucy would effectively be taxed as adults. With John, going back, if grandkids have got assets in the trust that's operated for 80 years, then you actually have to, what I would do there is at the end of 80 years, you need to vest. So what I would do is I'd probably set up 2 trusts if there were grandkids there, or numbered trusts, and effectively that would be the end of that trust. So you have to watch out for capital gains tax, the stamp duties. If one of the, like if I was doing a testamentary of these SMSF Death Benefits Trust, I'd always set them up in South Australia because it's the jurisdiction that generally picks it up. So that's a good issue. You just got to watch out for that vesting. Daisy, can I please get a link to tomorrow's presentation? So the easiest way to do that, Daisy, is, and I'm just going through, if you just go up, you'll see here on the front page of our site, you just see weekly webinars. So you just go upcoming webinars. So you can see I'm doing this one today. In fact, I don't even know why there's one not tomorrow. What I'll do is I'll send this out this afternoon, Daisy, out to everyone who's been on this call. So just going through what I'm going to look at tomorrow. So just watch out for that one. Thank you for bringing it to my attention. Okay, so we've done, let's go back to our little bloodline slide. We've done succession control, asset protection, superannuation, taxation, and estate planning. The last point, so I've done the estate planning in the SMSF and directly out of the SMSF, so I don't want to go to the estate. I've done it through the leading member trust or that living trust. So I have to do those anyway. Now, the traditional estate planning, you generally do a will with a testamentary trust. But again, that runs counter to what we've been doing by putting all the assets and equity over to the living trust. Now, if I was doing a traditional will, obviously it's the assets in joint names. So that would go to Bill. The residual estate after paying tax and debts, and the debt, obviously the major debt is that living trust. A beautiful thing about that, the trustee of the living trust has also got the option to acquire the property. So in that instance, remember, the call option is to acquire the property for 1.2, but remember, the estate actually owes 1.2. So effectively what would happen is that there would be an acquisition of that property, and then that would go over to the estate. Now you just got to watch out. If we do it right, if it's principal place of residence, you'll be able to get exemption there and potentially stamp duty issues as well. So it goes to Bill, and you build a testamentary trust, but that's optional at Bill. If Bill's not alive, then we want to put it automatically into a testamentary trust. You'll see through our system, you can either have an optional testamentary trust, an automatic one. So here, if it's going to go to John or Lucy, we'd want to make it automatic. And then have a guardian board up until age 25. And more importantly, from there, you might want to, again, limit the remember the same thing as we did before. It's exactly the same as a living trust. Effectively, what you're doing there is you can have a certain amount of income up until age whatever. Corpus or capital, we can't use that unless it's for, maybe a deposit on the first home or paying for educational expenses. Or more importantly, you can put in caveats, remember, around drug addiction, so on and so forth. These are bespoke, so you're building these for clients. So I'll watch out for that one. Okay, so that's our traditional one. So we've gone through that 5 sets. So let's go through to the case study 3. We've got a couple of business owners, investment property, SMSF. So this is a bit tougher one, but it's exactly the same. So we've got Alice Brown, who's aged, so Harry Papadopoulos, can you set up an SA even if you have no link to the state? Absolutely. Because you'll find that when you have family trusts, you might have trustees in different states, you might have appointors in different states, you might have assets in different states. So there needs to be, you need to choose a jurisdiction in your documents. So when you come around to add documents, that jurisdiction is all important. So you choose South Australia. And if you don't make any choice, so there's no law that applies, then you've got to go, if there is an action, then you're going to have to find out where it's closely held. Well, where's the trustee? And if you can't find the trustee, then it goes obviously to where the assets are held to find the jurisdiction. So we've got Alice Brown, age 48, has a marketing consultant firm that runs through the Brown Discretionary Trust and advises large companies on marketing strategies. So that's good. So there's good money coming through there. Her spouse for 8 years is Sam, who's age 36 and runs a cosmetic surgery via his company, Sealer Proprietary Limited. So again, that's good. Alice has 2 children from a former marriage to Steve Brown and a child with Sam. So she's got Anne and John, 24, 21, to a former spouse, let's say she doesn't like and wants to make sure she keeps money away from them. And then she's got Bobby, who is 10-year-old to Sam. So this is a classic blended family. They've got a home in Surrey Hills in Sydney worth $3 million. It's got no debt, so obviously she paid it off. Got 3 investment properties worth $2.2 and $2 million debt. They've also got their own super fund. Alice's account's $550, and Cherie's, shouldn't be Cherie, sorry, it should be Sam, is at $250,000. So again, same thing. What are we going to do? Succession and control, asset protection, superannuation, taxation, and estate planning. So really, it's going to be much the same sort of thing. It's a little bit different though with blended families. So Alice is the leading member, the first in the line of succession. And I'm going to look at Alice first, and then we'll look at Sam a little bit later on. So something happens to Alice, so she's sued, has an accident or whatever, or dies, Sam's the next in line. So remember, this is much the same as Mary and Bill. So ideally, Sam's going to be Alice's enduring power of attorney, executor, etc. Now, an alternative to that could well be that it's going to be Alice, and then it may well be Anne and also John. But what I would suggest there is it's probably Alice, then going to Sam, but Sam would get binned if there was a divorce. So you just remove Sam as the leading member appointor. So that's fine. Remember, Alice is the one who controls it. So don't need, Sam's signature or anything. And that happens inside of SMSF as well. So you can actually, you'll find with the leading member SMSF, if they weren't getting along, Alice as a leading member of the SMSF can remove Sam within a period of 60 days. So anyway, who's the next in line? I probably have Anne and John is one. So again, you could have Anne, then John. So it may well be, so when you're discussing it with Alice, it goes Alice, Sam, and then Anne and John together, or Alice, Sam, Anne, and then John, and then potentially Bobby there as well. Alternatively, it could be Anne, John, and Bobby, and then you put a guardianship board in there as well with a couple of advisors. So we need to get that line of succession, and there's a couple of different options there with a blended family. For Sam, it's obviously going to be Sam, Alice, and then Bobby. unless he gets on really well with Anne and John. So it's Sam, Alice, and then Bobby down that track. But you definitely need a guardianship because Bobby's only 10. So you can see once I get that succession line, I'm in pretty good position. So the leading member living trust, exactly the same. So I'd get Alice's, again, it's going to be the same thing we talked about, remember with Mary around, do we set up quite a separate trust? Given where they are in their life, it might be an idea to do so, but certainly if this is a discretionary trust and she's running her marketing consulting business out, I'd definitely make it a leading member discretionary trust anyway, and then probably consider, given their wherewithal, I'd probably set up a separate living trust or family protection trust for that when we set up the protector. But anyway, so I'd upgrade the existing discretionary trust. So you got Alice, the next in line, next leading member appointor is Sam, and then it goes down to remember we looked at this, it then goes down to Anne, then John, and then Bobby. They're all going to be included as beneficiaries. With this one, you'll find when you're drafting up or when you're going through your interview, you've got to make a choice of whether to include Sam as a beneficiary or exclude Sam. So it's up to you. But if they're getting on well, then you include, but at any point in time, you can move them anyway. Same thing, corporate trustee. So it's exactly the same as Mary. My preference, shares, leading member, much better than successor director solution. So that if something happens to Alice, her shares are cancelled, goes to Sam, so on and so forth. So the big issue there is if Sam dies, again, we have those children with subtrusts. So that'll be Bobby and John, much the same sort of one. And watch out for that. That's coming out very shortly. In the next, hopefully next month, we'll have those subtrusts. I'm working on one at the moment. So usually our process is at Abbott Morley, we build it specifically for a client, and then what we do is we template it and put it up on Lightyear Docs. So should it just be one general trust, or should it actually be a sub-trust in that instance there as well? So again, we just need to have a look. So leading member of the trust. Protector, exactly the same sort of thing. I probably would set up a separate family protection trust, same thing. When I do that, the family protection appointor, which you can do inside the protector, is going to be Alice, Sam, then I think is it Anne, then John, then Bobby. So we go down exactly the same thing. So you can see how it's a formulated modulaic approach. And again, we'll have that option agreement there. The net equity is $3.25 million. So we move on from there. So that's a protector. Again, gift over by way of a promissory note. Remember, it's not cash. Promissory note comes back, but it comes back as part of a loan agreement. So what are we going to do with Sam's company? Then in that instance, you could either have a separate family protection trust, one for Anne and the family, and then one for Sam and the family. So he could put it all into a consolidated one, but you don't know what you don't know. Some clients will, some clients won't, particularly if they've been burnt pretty heavily in marriages before. So what we can do is we can transfer the equity of the company. So he'll obviously have equity in the shares, can transfer those over. And again, alternatively, what we can do is if he's a cosmetic surgeon, he's got a whole databases, he's got processes to have heaps of equipment. So we can actually transfer those over to a family protection trust and then license or lease them back. So that's not a bad idea either one. So we can transfer the underlying value of the shares and also the assets as well. So then Sam would be the leading member, Alice, and then Bobby. And you can bring the other children in, or they could effectively be guardians. So the question is here, what's going to happen in the event that both Sam and Alice pass away yesterday? So building a leading member SMSF, absolutely, exactly the same thing. We talked about the accountant's exemption. It's all exactly the same. Alice is the leading member, Sam. This would be a 5-member fund. Again, remember, we can get insurances from age 2. So I'd be getting Anne, Bobby, and I keep on forgetting the names, it's crazy. Anne, John, and Bobby in their insurances as well. And again, same with tax-wise, each of those kids can effectively be employed or get trust distributions and transfer them on into the superannuation fund if there's spare cash, obviously. Estate planning, exactly the same thing as we looked at before. Now, I hadn't got to those slides yet, but it's going to be exactly the same. So when we have a look, though, is the dangers we want, and this is where my preference is that if we have a blended family and put everything over the estate, we might create the most beautiful will with testamentary trust for everyone, but then it's going to get challenged under a family provisions claim, particularly if the children don't get on well with Sam, which can quite often happen. So we might have a fight between Anne and John and Sam. And the better thing to do is if Alice has got her own family protection trust, as the kids get older, then you can probably drop out Sam, because remember, it's got those assets. The same with Sam, could drop out Alice. So it then just goes from Sam down to Bobby, so that you're being looked after quite separately, so that there is no family provisions claim. So that's the way that I would do it. The same thing inside the SMSF. The SMSF is a little bit more robust. You can't make a family provisions claim against the SMSF except potentially in New South Wales, but not to any great extent. So again, you can do the same sort of thing so that when the benefits are paid out, so it can go, from example, Alice partly to Sam, and then to John and Bobby, to Anne, John and Bobby. You could either have one testamentary trust or one death benefits trust, or you could have a separate one for each. Depends on where their balances are at the moment. It's probably not to any great extent. But again, that's how we would deal with it, with that situation. Does that make sense, everyone? Does that make sense in terms of how we deal with a blended family? So it's exactly the same as what we did with a simple one, but what we've done with a blended. So if you had a look at your client base, and we started here, we've got here just like mum and dad, you've got lots of clients that would fit into exactly this profile. But as you can see, we go through the 5-step succession and control, asset protection, super, taxation, estate planning. And then likewise, when we have case study 3, there's a bit more detail, a lot more money, and more importantly, a blended family. We go through the same thing, but we just have a different twist. So instead of just having one family protection trust, you end up with 2, one for each family. And I think that's absolutely crucial. So as we go down the track, as I said, from our perspective, watch out for next week. This is, I'll send out a copy of this later on today, but I'll send out an email about what's happening tomorrow. Key thing for us, though, is when we go down the track within the next week, there'll be a release of the certification course. We will, in fact, be utilising these exact case studies, believe it or not. But what we'll be doing is going down and driving down into the legislation. So at the moment, you're just relying on my skills to tell you what it is. But what you need to do is have that ability to go in and have a look at the legislation, find out where it is, and then come up with solutions like this. So that, by the end of those 3 days, you're going to pull apart, from small to large funds. You're going to be looking at what happens if you've got disabled children, everything like that, but you'll get accredited on that or certified, which would be great. So that's coming out. So watch out for that. It's now perfectly 2:30. I'll send out all these slides as well with a copy of this presentation. And I look forward to seeing tomorrow, where we'll have a look at member exiting a self-managed super fund, plus the SMSF accountants letter. Plus, I'll see there's a couple other releases I'll go through around wills. We've got a really good new section in our wills where you can specifically exclude individuals from the will and the reasons why. So I'll bring out a lot of that tomorrow. Anyway, it's Grant Abbott signing off, and thanks a lot for Michael and his great input as well. It's been absolutely useful. It's Grant Abbott signing off.